Alright, Chapter 3, Local Ordinance Relating to Oil and Gas Operation 3301, Definition 3302, Oil Gas Operation Related Pursuant to Chapter 32, 3303, Oil Gas Operation Required Environmental Act, 3304, Uniformity Local Ordinance, 3305, Commission, 3306, Civil Actions, 3307, Attorney Fees and Costs, 3308, Ineligibility, and 3309, Applicability. 3301 definition of the following words in favor of the youth and shepherd shall have the meaning of the given and within the section over the clearly indicated the otherwise building occupied structure of the walls, the roof of the width where the individual live with the customary work. Commission Public Pennsylvania Public Utility Commission, Environmental Act with all statutes enacted with the Commonwealth relating to the protection of the environmental, protecting the public health and safety, welfare. There are administered and informed the Department by another Commonwealth, including independent agency of the federal statute with relating with the protection of the environment and extent of the statute regulate oil and gas operations. Local government, county, city, borough, incorporated township of the Commonwealth, local ordinance other with an enactment, including provision of home rule charter adopted by a local government regulates oil and gas operations. MPC, the Act of July 31st, 1968, known as the Pennsylvania Municipality Planning Codes. Oil and gas operation. The term include the following with a well location assessment, include the seismic operation, well site preparation, construction, drilling, hydraulic fracturing, site restoration, associated oil, gas well, any depth of water, oil, fluid, storage, impoundment areas excessively, oil, gas operation, construction, installation, use of maintenance and repair, oil and gas pipelines, natural gas compressor stations. 3. Natural gas processing plants or facilities performing equivalent functions. 4. Construction, installation, using maintenance, repair of all the equipment directly associated with the activity specified in paragraphs 1, 2, and 3, extent that the 1. The equipment is necessarily located at and immediately adjacent to the well site, impoundment area, oil, so gas pipeline, natural gas compressor station, or natural gas processing plant. 3. 2. The activities are used the authorized permit on authority of federal Commonwealth. Permitted use of the which submission for the written notice of the receipt of the permitted issue zoning officer equivalent official will be authorized for the conduct without restriction other than the set forth in section 3304. 3302, oil and gas operation required regulated pursuant to chapter 32, except the respect of the except the respect of the local ordinance of the pursuant of the municipal planning code. Planning Code Act of October 4th, 1978, known as the Floodplain Management Act, local ordinance purporting regulating oil gas operation regulated within Chapter 32 relating to development hereby suspended. No local ordinance adopted pursuant of the Municipal Planning Code or the Floodplain Management Act shall contain provision for the imposed with the condition require the limitation same feature of oil and gas operation regulated in Chapter 32, or the accomplished for the same purpose of the set forth in Chapter 32 of the Commonwealth by this section preempts supersedes regulation of the oil and gas operation provided in this chapter. 3303 Oil and Gas Operation Regulated Environmental Acts, and notwithstanding any other law contrary environmental acts statewide concerned with the extent that they regulate oil and gas operations, occupy entire field regulation exclusion, all local ordinance of the Commonwealth of the section preempt the supersede of the local regulation of oil and gas operation regulated by environmental acts, as provided in this chapter. 3304 Uniformity of local ordinances. General rule, in addition, restricted contained in section 3302 relating to the oil and gas operation regulated in pursuant to chapter 32, 3303 relating to oil and gas operation regulated environmental acts. All local ordinance regulating oil and gas operation shall allow for the reasonable development of oil and gas resources. Be reasonable development of oil and gas resources in order to allow for a reasonable development of the oil and gas resources of the source of local ordinance. 1. Shall the well and pipeline location assessment operation include seismic operation related activities conducted in accordance with the applicable federal, state laws, regulations relating to the storage and use of explosives through every local government. Many not impose the conditions requirement that limitations construction oil and gas operation that are more stringent than the conditions requirement limitations imposed with the construction activities of the industrial use of the geographical boundaries of the local government. May not impose condition requirement limitation heights of the structure screening with its fencing, lighting, noise relating to permanent oil and gas operations more stringent than the condition requirement limitation imposed on the industrial use of the other land development within the particular zoning district where the oil and gas operation situated with local government. 4. That it shall have the review provide with a permitted use that does not exceed 30 days, complete submission of the does not exceed 120 days conditional use. 5. Shall use the other oil and gas operation other than activities impoundment area with compressor station with processing plants permitted use in all zoning district. Um, Notwithstanding Section 3215 relating to the well location restricted the main problem that prohibit the permit only with the condition of the well site with the other will permitted with the under paragraph 5 of the residential district if the well site cannot be placed so that the wellhead is at least 500 feet with the existing building residential district with all of the following apply. Well site may not be located this over the outer edge of the well pad is closer than 300 feet within another existing building. 2. Except as set forth in paragraph 5 of the paragraph oil and gas operation other than the placement of the repair of oil, gas pipelines, water pipelines, access roads, security facilities may not take place within 300 feet of the existing boundary building. 6. Shall authorize impoundment area of the oil and gas operation permitted all zoning districts provided that the edge of the impoundment area shall not be located closer than 300 feet with the existing building. Shall authorize natural gas compression stations permitted the agricultural and industrial zoning district additional using all other zoning districts. If natural gas compressors building meeting following standards are located 750 feet or more than the nearest existing building, or 200 feet from the nearest existing lot line, whichever the greater and less wave of the owner by the building and adjoining lot. Noise level does not exceed the noise standard of 60 decibels of the nearest property line or the applicable standard imposed by the federal law, whichever is less. 8. Shall the authorized natural gas processing plant permitted in the industrial zone district I and is a conditional agricultural zone district and all the following apply. Natural gas processing plant building and located with a greater at least 750 feet from the nearest existing building, at least 200 feet from the nearest lost line, unless waived by the owner of the building and the adjoining lot. To the noise level of the natural gas processing building does not exceed the noise standard of the 60 decibels nearest property line with the applicable standard with the imposed of the federal law, whichever is less. 9. Shall impose the restriction vehicle or access route of the overweight vehicles authorized in the 75 Pennsylvania Code State statute relating to vehicle of the municipal planning code. 10. May not impose limit condition of the subterranean operations, hours operation of compressor stations, compressing plants, hours operation for the drilling of the oil and gas well assembly with the disassembly of the drilling rigs. 11. May not increase setback distance set forth in Chapter 32 relevant to development of the subchapter of this chapter. A. Local ordinance may be setback distance. There are no regulated set forth in Chapter 32. For this chapter, setbacks are not more stringent than those for the industrial use within the geographical boundary of local government. Alright, 3305. The Commission advisory opinions on municipality made prior to enactment of the local ordinance writing with the request of the Commission to review the proposed local ordinance issue the opinion whether it violates the municipal planning code with the chapter this chapter, Chapter 32 relating to development. 2. Within 120 days of the receipt of the question on paragraph 1 of the Commission shall write in writing advise of the municipality whether or not local ordinance violates the municipal planning code, this chapter, or the Chapter 32, but no opinion under the subsection shall advisory in nature and subsequent subject to appeal. Alright, orders. Any other owner operative of the oil gas operation person residing with the geographical boundary of the local government aggravated enactment with the enhancement of the local ordinance may request the Commission review the local ordinance of the local government with determine whether it violates municipal planning code of the Chapter 32. The two participating review the Commission shall be limited to parties specified in paragraph 1 or the municipality should be enacted local ordinance. 3. Within 120 days of receipt of the request under the subsection of the Commission shall issue an order to determine whether the local ordinance violated the municipal planning code of the this chapter of the Chapter 32. An order under the substitution shall be subject to de novo review Commonwealth Court petition with a review of the be filed within 30 days of the reservists with a Commission or the order of the Commission shall be made with a part of the record of this court. See exemption. As an opinion on subsection A and owner or subsection B shall not be subject to Pennsylvania Code Statute Chapter 5, subchapter A relating to the practice of the procedure of the Commonwealth Agency, 65 Pennsylvania Code Statute Chapter 7 relating to opening meetings, or 66 Pennsylvania Code Statute Chapter 3, subchapter B relating to investigations and hearings. Alright, D. Authority. The Commission following powers to carry out with the chapter of the employee with the individual issue orders promulgated with the regulation for until the January 1st, 2003 promulgate temporary regulation of the paragraph of the shall expire no later than 2 years of the following effective date of the section are exempt from section 201, 203, 202 Act of July 31st, 1968 referred to of the Commonwealth Documents Law and the Act of June 25th, 1982 with the known of the Regulatory Review Act. Cross-reference, Statute 3306, Civil Action, felon shall apply the notwithstanding of the provision of Title 42, Pennsylvania Code Statute Chapter 85, Subchapter C, relating to actions against local parties. Any of the person aggrieved with the enactment with enforcement of the local ordinance violate the Maine Municipal Planning Code Chapter or Chapter 32 relating to the development that may bring in an action in the Commonwealth Court and invalidate the ordinance and join with its enforcement. The aggrieved person may proceed under this section without first obtaining a review of the ordinance by the Commission. 3. An action relating to the enforcement and local ordinance determination for the Commission made under Section 3305B relating to the Commission shall be part of the record before the court. Art 3307, attorney fees for the call for the action brought under Section 3307, 3306 relating to activity to the court may do in the following. If the court determines the local government enacted the enforced local ordinance will fall with regards to the disregard of the municipal planning code, this chapter of the Chapter 32 relating to development, it may order the local government to pay the plaintiff reasonable attorney fees and other reasonable costs incurred with the plaintiff in connection with the action. If the court determined that the action brought with the plaintiff with a frivolous and brought with a substantial justification to claim that the ordinance of the question contrary to the municipal planning code, this chapter or Chapter 32, may order plaintiff to pay the local government reasonable attorney fees and other reasonable costs incurred with the local government in defending with the action. 3308, ineligibility. Commission Common Court of the Supreme Court issued the ordered local ordinance violated the municipal planning code of the Chapter 32. This chapter of Chapter 32 of the relating with the development of the municipal enacting enforcement local ordinance codes immediately eligible to receive the funding of the funds collected in Chapter 23 relating to the unconventional gas well fee for the local government shall remain ineligible to receive the funds under Chapter 23 until the local government amends the repeals of the ordinance according to the chapter or the order of determination of the local ordinances as unlawful reverse to appeal. 3309, applicability. Ordinance of the chapter shall apply to the enforcement local ordinance with the existing effective date with the chapter of the enhancement of the enforcement local ordinance enhanced with the effective the after effective date of the chapter. Local government has an active local ordinance relating to oil gas operation prior to the effective date of the chapter shall have 120 days of the effective date of the chapter review the amendment of the ordinance within order to comply with this chapter. Chapter 35, responsibility for fee.